Hi, this is the 3D printing lawyer. I'm making this video after watching Zack Freedman's video here about the Benchy Baron. I love Mr. Freedman's channel. He raises some very interesting questions in this video about the Benchy. I just don't always come up with the same answer. Mr. Freedman alleges that he got copyright law info from Peter Lemire, and he could be right, but it's also possible that I could be right. Perhaps we'd just be on different sides of the courtroom on this. I'm not an expert. I'm continuing to learn new things on copyright law every day, so I can admit when I'm wrong, but I'm going to explain it the way that I understand it, and the way I understand that these things can be looked at in multiple ways. Not trying to take an opposite stance to Mr. Freedman's opinion, and will try to provide a fair analysis. If you stay into the end of my video, I'll tell you how to get rights to the 3D Benchy without any limitations.
If you've seen a 3D printer, you've probably seen a 3D Benchy, so I will keep the intro quick. The Benchy is a little printable tugboat with cartoonish proportions, and as its name suggests, it is a technical benchmark. If you need to test out a printer, calibrate a setting, dial in a new filament, or a few hundred filaments, some part of the Benchy probably provides the data you need. It isn't just a waste of polymer, it is a comprehensive stress test of the whole printing process from file to finished product. Every aspect of the Benchy is intentionally difficult to print but easy to measure, and since it takes less than an hour and barely 10 grams of filament, and it's really cute, this little marine vessel rapidly became the de facto lorem ipsum of 3D printing. It is so ubiquitous, Prusa Slicer has it built right in, and Bamboo Labs printers ship, as it were, with the Benchy preloaded and ready to print. There's even a speed run. As of January 2025, the current hashtag speedboat race record is 1 minute and 53 seconds. It looks like dog shit. Like most printable models, Benchy is distributed for free as an STL file. You load this file into a program called a slicer, which converts it into commands that the printer follows to deposit raw material and produce a physical tchotchke. The laws at play, and by that I mean like legal laws, not like laws of physics, they only care about the Benchy's file, not the print that file produces. So
this isn't necessarily true. Copyrights don't include what the file produces, but it also doesn't include the file itself. Once you understand that the rights are completely separate from the work, copyright law actually becomes a bit more intuitive.
When you see me handling plastic boats, just be aware they're for illustrative purposes only. It's just more fun to look at a physical wing doodle than a boring screenshot. The 3D Benchy was originally created by two Swedish guys, Paul O'Keefe and Daniel Nore. At the time, they were working for a company called Creative Tools, which sold, serviced, and specialized in 3D design software. It was 2014, and they were printing a lot of frogs, specifically Marina P's tree frog. Printers have a hard time rendering sloped surfaces, so the frog's belly and back make a particularly brutal torture test. Paulo and Daniel realized they were wasting time and filament printing the rest of the frog, so they decided to isolate the hard parts. But then, in a phenomenon rarely witnessed in the 3D printing community, they got carried away. Some holes here, some pillars there, some tricky tubes, funky curves, awkward slopes, cutesy cutouts. Let's just say Daniel was still modeling when Paulo picked the name, which is why it's called a 3D Benchy and not a 3D Boaty. In April 2015, almost a decade before this video, Creative Tools posted their work to the file sharing site Thingiverse, and to their surprise, their adorable nautical stress test almost immediately became the single most popular item on the entire website, then proceeded to become the single most popular object in printing. I cannot stress how insanely popular this model is. Like, I would bet almost every printer that has printed anything has printed at least one Benchy.
Mr. Freedman isn't serious here, but I had never printed a Benchy until my fourth 3D printer, which was the Bamboo A1. Then since it was already on the SD card, I finally printed my first Benchy.
With popularity comes mimetic energy, and silly Benchy parodies are among the printing world's most beloved inside jokes. From intricate objet d'art like JD Max Ghost Ship, to goofy gags like Lee Sherm's Flex Benchy, to actually useful stuff like Pandoranium's Benchy Bookend. This silly boat has inspired about 5,000 derivative models. My channel alone has featured nearly 100 modded Benchies, screwed, chopped, buffed, fluffed, rocked, racked, wrecked, planed, trained, and automobiled. This one has a hat. Building off other people's models is the bedrock of the 3D printing community, which is why so many makers are surprised to hear the license of the most popular model explicitly forbids modifications. Most printable files have a non-commercial license. You can do whatever you want with the STL file as long as you give it away for free. But Creative Tools released the Benchy's files under Creative Commons 4.0 attribution, no derivatives. This license grants you the rights to share or even sell the files, as long as you agree not to change anything. In an interview with all3dp.com, Paulo explained we chose the no derivatives option to make sure the same version of 3D Benchy is used when people compare 3D printers, materials, and settings. The key word here is consistency. Throughout its whole history, they've maintained absolute conviction that if others can change it, they'll debase its value as a benchmark. They held fast even as their work passed 2 million downloads, even as it became literally iconic, and even as their employer Creative Tools was bought out by NTI, a Danish enterprise IT firm that earned about 247 million euro in 2024.
I made a mistake in my previous video apparently, because I had said that Creative Tools had been purchased by NTI Sweden, a Swedish company. Apparently it was bought by NTI Group, a Danish company.
To my knowledge, every single modified Benchy ever released was done in blatant defiance of its creator's explicit conditions. And sure enough, a huge number of transmogrified tugboats I've trotted out in past videos have been redacted from the web. Some of the STL files in my downloads folder could be the only printable copies on Earth. The Benchy's unusually hostile license has been a very well-known powder keg since its inception, and to be totally honest, I am kind of surprised it took this long for someone to stub a cigarette on it. Said stubber was Maker Joe, who allegedly watched Printables unceremoniously delete a number of his silly and a little bit spicy remixed Benchys. After Printables sent his glitched out Benchy to the Shadow Realm, Maker Joe questioned their actions. An alleged Prusa research rep tried to pacify him with bland corporate boilerplate, saying the company had to respect the license, and were actually removing all Benchy remixes, not just his. The exchange left Joe so furious, he pasted the screenshot to the 3D printing subreddit, along with, I would say, a little too much editorializing. But this was the cause the community was waiting for. Thousands of nerds, presumably seething over greedy corporate IP trolls, had finally found an opening to vent their high-pressure, impotent rage. This is where tech media picked up the story, threw it out the window, and in my opinion, fabricated a bunch of bullshit.
9-digit Megacorp declares apocalyptic war on the world's most beloved 3D model, mobilizing an army of ruthless corporate lawyers to bury the hard work of innocent amateurs beneath a deluge of DMCA takedowns. Oh, the humanity!
The way this was reported was completely detached from reality.
DCMA.
Independent outlets I usually respect, like Hackaday, Tom's Hardware, and fellow YouTubers, heard the words big company, takedown, and 3D printing, and their desperate haste for first mover clicks apparently made up the rest.
DCMA.
This does not seem to have anything to do with copyright.
Mr. Freeman and I came to the same conclusion. I was saying, if someone actually made a DMCA takedown notice, I want to see it, because I want to know what they declared under the penalty of perjury. As it turned out, there was no DMCA takedown notice.
In fact, there's a decent chance it can't have anything to do with copyright. I understand that people are pissed about copyright abuse, but to my understanding, Benchygate isn't even in the same branch of law as copyright. When it comes to websites, some fairly recent legislation lays out a very specific structure for how rights holders like NTI, content hosts like Printables, and users like Maker Joe, I wrote interact, but it's supposed to fight each other. You know this process as a DMCA takedown, but here in the land of cheese curds and mobility scooters, it's more accurate to say they're following the Online Copyright Infringement Liability Limitation Act. This is a US federal law that creates a conditional safe harbor for online service providers, and I ripped that sentence directly off Wikipedia because I just couldn't phrase it any better. If a website agrees to follow a very specific protocol when asked to remove a piece of allegedly infringing media, they cannot be sued for hosting it. To any site that allows user-generated content, maintaining safe harbor status is a matter of life and death, and they will do flaming backflips to avoid it.
Printable's terms of service clearly require users to follow check law.
Objection! The DMCA contains the American implementation of the World Intellectual Property Organization Copyright Treaty, the same agreement that shaped the European Union Copyright Directive. The takedown process in America and the EU are therefore almost identical.
Yes, that is basically true.
I don't really get the cartoon about check law, but it's more relevant on where the website is hosted than who owns it. Since Printables is using Cloudflare, the content is almost certainly hosted in the same country as the user of the website. Anyway, the Creative Commons license is an international license, and since it doesn't say what law will apply, it will be the law where the exercising of the rights occurs. Most U.S. citizens are not going to be prone to check law, especially since it's not Printables that is granting the license. The terms and conditions for Printables would apply where the user had a constructive knowledge of them. This would be the case for someone that had created an account because there is a click-wrap agreement at that time. However, no click-wrap agreement to download. Also, terms and conditions, being conditions, aren't a contract. If you don't follow them, then you simply aren't supposed to use the website.
Most of my audience is American GigaChad, so I'm going to continue saying DMCA and other American terms. But the rest of you betas can mentally substitute whatever your tin pot backwater decided to name your WIPO implementation. I am curious about how the specifics vary country to country, so please let me know how things fly in your neck of the woods. Or the middle of the ocean if you're the single permanent resident of the Principality of Sealand. I know you're watching, Prince Michael. You better join my Patreon. I know where you live. The takedown process begins when the owner of a copyright notifies a website that a specific piece of content infringes their rights. This is not as easy as clicking report and selecting something on a dropdown. They have to prove they're authorized by the rights holder, they have to provide real-world contact information, and they have to assert that they're fairly sure the material actually is infringing, among a bunch of other facts. This is all a sworn declaration on penalty of perjury, and while I don't believe anyone has actually been convicted for filing a felony bullshit copyright strike, you have to be a seriously ballsy troll to gamble with 5 years in prison. The host reviews the claim, and if it seems legit, they're obligated to quickly take down the material. But this isn't the end. They also must notify the uploader by sending them what we call a DMCA notice or a copyright strike. This is not optional. If they don't notify users of takedowns or provide them enough information to sue the filer, they lose their safe harbor status.
Mr. Freeman seems to have this slightly backwards. It's a DMCA counter notice that must have the information necessary to sue the alleged infringer.
The point is, content hosts like Printables really do not want to go off script, and as far as I know, Maker Joe did not receive a DMCA or EUCD notice. It's safe to assume Printables is not deleting Benchys due to copyright claims. Going after Benchys in particular would be extra dangerous. For one, the modified Benchys could well be considered works of parody, and that could be a strong defense against alligators of copyright infringement.
Using a copyrighted work without permission under fair use as a work in parody doesn't give you the right to distribute the original work. The person that added the birds to the Benchy could distribute the birds without the original work. Posting a picture of it on Reddit is fine. Uploading that file to printables would not be fine.
But more interestingly, the Benchy may not even be eligible for copyright in the first place. This is a bit of a moot point because I don't think Benchygate is a matter of copyright. But the idea that the Benchy, and by extension many other 3D models, may not have enforceable copyrights in the first place is extremely fucking interesting. And Brooke really wanted me to keep this part in, so this one is for you, my love. She went like this. Of all the ways to defend your intellectual property, copyright is by far the longest lasting and the most powerful. That's why it has a very narrow definition. Here in Eagle Land, a copyright protects a creative work fixed in a tangible medium. Nothing else. Don't be misled by the word tangible. The law classifies the Benchy's STL file as either code or a data set, and both do count. No, I'm challenging the first part. I don't believe the Benchy is a creative work. In fact, I don't believe a court would think the Benchy is a creative work. In fact, I think the Benchy's creators went above and beyond in obliterating any possibility of a court calling it a creative work. Creativity is a wishy-washy concept, but its definition is not really important. What matters here is when it comes to a useful object, copyright does not protect any elements that give it its function.
The reason why it doesn't typically protect functional elements is because they would more than likely be a process or idea and not an expression, and copyright doesn't protect those.
That would be the domain of patents. The US Copyright Office uses a fancy chair as an example. The design carved on its back could get a copyright, but the rest of the chair needs a design patent. Saw off the seat, the back, or leg, even if they're really cleverly designed or they look really cool, if it's not a chair, it's not part of the copyright. When it comes to the Benchy, well, it doesn't come to the Benchy. I'm only shooting this rant because Paulo and Daniel were so adamant that changing literally any part would void the Benchy's use as a technical comparison tool, they picked a license that explicitly forbade doing so. They made it unambiguously clear every single triangle of the Benchy's STL file is necessary to fulfill its purpose.
Mr. Freedman is exaggerating there. The creator did not say that every triangle is only for a functional purpose. More on that in a second, though.
That's kind of lame, so let's ignore that and do this the hard way. Disentangling form and function can be tricky because it's not like the designers publish a pamphlet explaining the exact reasons they designed in every detail. Except for this time. In a PDF brochure once hosted on 3dbenchy.com, the creators themselves introduced their eponymous dinghy as such. Hashtag 3dbenchy is a 3D model specifically designed to offer a large array of challenging geometrical features for 3D printers. Not creative edification for humans, not self-expression for them, geometrical details for printers. The brochure also estimates that the Benchy should take well under 2 hours to print, which is just precious. So let's use their own brochure to deconstruct the Benchy like we disassembled that chair. There actually is a Benchy with a chair on it, but let's tell our intrusive thoughts to stay on track. There is a Benchy that's also a train. I'm sure there's a pill I should have taken. Starting at the top, the chimney's concentric cylinders test the printer's ability to render roundness. Its dimensions are all whole numbers of millimeters, so you can verify all 3 axes in one place. The chimney shaft extends the Benchy's height to a nice round 48 millimeters, perfect for calibrating the z-axis. The roof is sloped at a shallow angle to deliberately reveal each layer. The gunwale, that's the rim part, does the same thing just with a more variable organic shape. The roof's fore and aft surfaces are exactly 23 millimeters apart, forming our main calibration reference for the x-axis. The bridge is actually 5 tests. The roof and front window test bridging, the printer's ability to stretch filament over thin air. The rear porthole reveals if the z-axis is trammed correctly. All of these are also dimensional tests with nice round numbers. There's even a tiny little ship's wheel in there, explicitly to challenge your material's ability to render inner geometry. I was ready to consider that creative, but no, this is one of the tests, and I actually have a bunch of Benchies that failed it. Moving to the deck, we have the hawse pipes. That's what the little front holes are called. Sailors got weird names for everything. These verify dimensional accuracy against organic surfaces and reveal problems with ghosting. If the printer is wobbly, a shadowy streak will appear next to embossed and debossed details. On the aft deck, we've got the box thing, and it's a full suite of reference dimensions for inner and outer surfaces. It also happens to satisfyingly fit the smokestack, so if 2 Benchies are both accurate, you can interlock them like a yin-yang of yachts, a samsara of schooners, a tomoe of tugboats. However, there's no evidence that this was intentional. You can only copyright things deliberately designed by humans. Sorry, Naruto the ape and self-published AI slop farmers, you must be this sentient to copyright the copy roller coaster.
That is cute. I did not know you could spoon your Benchies. He probably references the ape here because there's a famous copyright case where a monkey got a hold of the camera and took a picture, and the courts said it wasn't copyrightable. It doesn't have to be deliberately designed, though. I'm sure that many of the features of a hand-sculpted work were happy accidents.
Far stern be a tiny little slanted tube explicitly meant to hold a tiny fishing rod. Barely any printers can actually print that fishing rod. So I would throw Creative Tools a bone and say it's aesthetic, but their own brochure's features page specifically highlights this as a very small, slightly slanted blind hole. Swinging back to the bow, CT's own story claims they started here and built the rest around it. So not only is this part for function, that function is kind of the only reason the Benchy is a boat in the first place. Meanwhile, on the stern is the actual hardest thing to print. So hard you may not even know it's there. A little nameplate on the stern reads simply hashtag 3D Benchy. The brochure implies these nearly unprintable 100 micron letters are meant for high resolution printers, which could could mean resin, but resin printers weren't that popular back then. The point is the nameplate is functional. Finally, on the bottom, we see some text reading ct3d.xyz. That's creative-tools3d.xyz, the designer's employer's former website. This currently redirects to NTI, but hasn't been changed on the bottom of the Benchy because it's also a test. This one is for first layer smushing, aka elephant's foot. There is one more detail, and it's not mentioned anywhere in the brochure. It is a tiny cylindrical void sunk horizontally into the very bottom of the stern, bestowing the Benchy with what can only be described as a boat butthole. No one ever mentions the boat hole, including the creator's own brochure, so let's call this orifice a creativity. So out of the entire 3D Benchy, the only detail that I think can be unambiguously considered creative is its puckered boat hole. As far as I know, everything else was explicitly designed to serve a function.
As I said before, functional elements typically aren't protected by copyright. However, this law has been interpreted to mean elements that are wholly functional. When an element is both expression and a function, it is still copyrightable if the expression can be separated from the function. It is a boat. The PDX design doesn't explain the function behind the boat shape. More than likely, all of the functions would have actually been easier to design if it didn't also have to be in the shape of a boat. And then, even if all of the elements were functional, the original arrangement of the functional elements could still be copyrightable. Whether they're functional or not, the obvious parts of a boat aren't copyrightable anyway. People have to be able to design tugboats without infringing, but if it ends up looking sufficiently similar to this one, it's going to be infringing.
If the gestalt ends up looking creative, it is likely pure coincidence. Now, this argument flies a lot better in the US than it does in the Czech Republic, where Prussia is based. The Czech Republic has particularly permissive copyright laws even among EU member states, and I believe they're much more willing to grant creative protection to a functional object. I believe they also ignore stated authorial intent. Instead, they look for signs of personal expression, with which the Benchy certainly drips. It drips!
This drippingly obvious creativity is what would make the Benchy protectable under copyright by a US judge.
I'm not sure the functional argument would fly in Prussia's home turf, but I did run it by a real American copyright attorney, and I was told it could be a strong argument here in Colorado. But this has all been a tangent. The alleged creators, whose alleged work Prussia Research allegedly deleted, did not allegedly get copyright takedown notices, allegedly. So every alleged article allegedly pushing about NTI, allegedly invoking the alleged DMCA, is so far off base its pH is negative. Yes, pH can go negative, allegedly. Do copyrights get abused? Constantly. DMCA claims wielded by liars with no claim to the IP frequently and fraudulently strangle obvious permitted uses of works that only the most neoliberally brainwashed judge would consider creative. This is none of that. In fact, this isn't even an intellectual property issue. The bench files is a matter of contract law. Do you remember that Creative Commons license? Well, you agreed to follow it when you downloaded the Benchy. You might not have signed any paperwork, and you might not have typed I agree. But Thingiverse does not let you click download without scrolling past the licensing info, and a court will likely consider that equivalent to a written contract.
I don't think scrolling past the link is going to count as a contract.
If you upload a remixed Benchy, you have broken your end of the deal. No ifs, ands, or boat holes. So every single one of these whack-ass modded Benchies, save the ones with specific written permission, probably represents a breach of contract.
Now this is an interesting theory. It's really clever, and I hadn't really thought of this argument. However, the court is not going to consider the Creative Commons license as a contract. There are two main reasons. Copyright law will preempt state contract law, so if the violation of the contract merely violates copyright and nothing more, it's a copyright issue, not a contract issue. The license on this is no copying for commercial use. That is a copyright issue. The only part that might remain a contract issue would be the attribution. Copyright law intentionally doesn't include such moral enforcement, so maybe there's a contract requiring you to attribute the author. However, we have to analyze the Creative Commons wording. Is it really a contract, or is it a condition of the license? If you read the license, it is clearly a condition and not a covenant. And so by not following it, you simply don't have a license. You haven't violated a contract. It would be enforceable under copyright only. And you're better off keeping it a copyright issue anyway because it'll be easier to sue. This contract would also fall under the statute of frauds, which requires the contract to be signed.
The contract holder, once Creative Tools and now NTI, is absolutely within their rights to seek these creators out and demand satisfaction. We are pansies who don't allow trial by combat, so your flagrant disregard for binding agreements instead exposes you to, drumroll please, basically nothing. If you break a contract, the consequences are limited to the stuff in the contract. The other party can recover money you unfairly gained, they can penalize you for money they unfairly lost, they can make you pay their attorney's fees, they can compel you to stop breaking the contract any further, and they can revoke anything they gave you under the terms of the contract.
Typically, a plaintiff can't make a defendant pay their attorney's fees under the American rule. I'm not sure why he says the damages are limited to stuff in the contract and then lists unjust enrichment at the same time.
The first three are irrelevant. The Benchy is a free model that doesn't even advertise its creators anymore, and trying to extract such a small amount of legal fees would cost them far more than they would get. You know, no money, no damages. We'll circle back to that whole compel you to stop thing because under normal circumstances it isn't necessary. Normally, the main consequence of violating a license agreement is that you lose the license.
He just explained why it's a copyright issue and not a contract issue.
The primary reason Creative Commons and similar so-called copyleft licenses even exist is to let users argue against a copyright claim. If I took a track licensed Creative Commons attribution and used it as background music in a video, I could still get a copyright claim. I would defend myself by showing them the license, proving that I am permitted to use that copyrighted content.
That is correct.
If the music were instead licensed CC non-commercial or CC no derivatives, that license would be void. I refused to hold up my end of the deal, so I lost the license, and the infringement is no longer permitted. This is the usual avenue of attack to enforce these kinds of licenses, which makes the lack of copyright action in this particular case extra bizarre. We have to fall back on the final mechanism. Simply breaking a contract lets the other party compel you to stop breaking it any further. Your reckless bench posting lets NTI threaten you with a cease and desist letter, and they can even compel you to take your stuff down by securing an injunction from a judge. However, this is nothing like a DMCA takedown. You can compel a service provider to take down a user's content due to copyright infringement. But here in America, if someone breaches your contract, you can only force the user to take it down themselves. You can't make the platform do jack shit. You remember how a content host can't be sued for its user's copyright infringement if it follows a certain procedure? Well, where I live, a content host can't be sued for its user's tortious actions or breach of contract at all. Zack from the future here. I am going to be honest, I completely forgot to record the scene the first time, which is why my hair is so silly. This almost absolute immunity is granted by Section 230 of the Communications Act of 1934. As long as an American website doesn't modify anything its users post, it mostly can't be sued over it. Instead, you can only sue the user directly.
Mr. Freeman is saying here that you can't use a DMCA takedown notice if it's a contract issue. And so you'd be limited to an injunction because an internet publisher isn't required to take down content that is in breach of a contract even if they're aware of it. He seems to be inferring that a publisher also has a safe harbor protection against an injunction, and only the non-publisher defendant would have to take down the content. Although a publisher is not required to take down content that is violating a copyright if they're aware of it unless they receive a valid DMCA takedown notice, a publisher must obey an injunction. Not being sued is not the same as not having to follow a court order.
Section 230 doesn't protect obscene, dangerous, or specific types of illegal material, for instance, things that infringe copyright. But otherwise, Section 230 is extremely permissive. Judges have only stripped it from websites like 3 times. It's arguably why the modern internet exists at all. Without something like Section 230, everything anyone would want to post to a website would have to be manually approved before it's allowed to go public. I could stuff the website of any American firm with terabytes of the most NDA-breaking, contract-shredding, blatantly deal-screwing over license-debasing, constitutionally unprotected dreck you could possibly imagine. And as long as it isn't too dangerous, too offensive, or too owned by someone else, there is dick all anyone can do to force that company to take it down.
A publisher doesn't mean to get involved in civil issues, but if it's aware of a criminal content on their platform, it does need to take action.
And it's worth mentioning, getting that injunction that forces you to take your stuff down is by design a real pain in the ass. Using the might of the state to destroy another person's work is like a micron away from stepping over the First Amendment, so judges tend to be like judicious. An injunction is a full-on legal proceeding and goes on the public record, so I scraped every database I could for any mention of a Benchy-related injunction. As far as I can tell, over a full decade of bald-faced breaching of boat-related bonds, the Benchy's Creative Commons license has never once been used to take a model off an American site.
I'm not sure why you would find an injunction in American law to take down the 3D Benchy. The process would be issue DMCA takedown, get a DMCA counter notice, maybe, register the Benchy under a U.S. copyright, sue, prove you've likely to win and get a preliminary injunction, or sue and win and get a judgment and then an injunction. Most lawsuits won't make it to judgment, though.
To force a model off an American site. Zack from the future here. I just want to clarify, if NTI wanted Benchy gone, the injunction would be the second stage. The first would be attempting to scare them into deleting their work by sending a cease and desist. Since those are threats of legal action and not actually legal action, they would never make it to the public record. But they also aren't confidential. Sending a C&D is far more openly aggressive than whatever the hell Maker Joe has found himself embroiled in. It's literally a declaration of war. If he got a C&D instead of whatever this is, this news story would be zestier and much more specific. The fact that no one's spoken up supports NTI's assertion that they aren't involved.
It is a common misconception that illegal action starts with a cease and desist. There are states where sending a cease and desist first can make the plaintiff be owed attorney fees if they win, but copyright is a federal law. I would start by sending a litigation hold letter that is basically saying, you're going to be sued, hang on to all the evidence. And then you include a settlement and release agreement if you want.
That said, if you have ever got a Benchy-related cease and desist and you still have the letter, please let me know ASAP because that will completely change the story. Now, I'm not a lawyer, so take the following statement with a grain of salt. Prusa research is not in America. This is where everything goes catastrophically wrong. Europe's copyright regime is largely similar to America's, but their other internet laws are not. The European Union's equivalent of Section 230 is called the E-commerce Directive, and while it also grants websites broad immunity for their users' content, it comes with a requirement to delete any illegal content the company is aware of, for instance by running a contest, or by handpicking certain models to feature on the homepage, or to award prizes with material value simply for posting content. The joke is Printables does all of this. These are like their selling points. It's why you post things to Printables instead of to, all their competition. So when some jackhole hit the report button and reminded Prusa Research that every single remix Benchy represents a tortious act, it didn't matter whether they worked for NTI, it didn't matter if those contracts would or even could be enforced. Prusa no longer had plausible deniability, so unless they showed good faith in wiping out all the illegal Benchies, they would lose their safe harbor protection and become the targets of thousands of frivolous lawsuits.
I wonder if Mr. Freedman has insider information, because I've been wondering who reported the license violations to Printables. In the US, unless it was the rights holder, Printables wouldn't have to and probably shouldn't take action, because you don't know what license Make for Joe might have gotten from NTI without Printables' knowledge.
Prusa's hands are arguably tied, but not by a corrupt copyright system, not by a Faustian contract, and certainly not by legal browbeating by a multi-millionaire megacorp. Prusa is forced to delete their users' content by their own decision to incorporate in the European Union and use their own website. Prusables put the handcuffs... Prusables. This, ladies, gentlemen, and cyborgs, is why, after 10 straight years of an entire community mixturating into Paulo and Daniel's wrong license choosing ass cornflakes, this shitstorm finally descended on Printables in particular. Thingiverse, Things, My Mini Factory, Umagine, GitHub, f***ing Pinshape. None of the most popular 3D model hosts are based in the European Union. Fine, Cults 3D is based in Cyprus and CG Trader is Lithuanian, and while both are EU member states, I've been told their adherence to the directives can be partial. Of every possible place to incorporate, Joseph Prusa picked one that would force his team to kill the Benchies whether they like it or not. Does this get Printables off the hook? Fuck no. Prusa Research might have no choice but to delete our content, but deleting our content sucks, and we will absolutely hold that against them. Or more pragmatically, we will mirror our hard work on one of the dozens of other hosts who will only delete our stuff if we tell them to. They are just as obviously illegal, everyone knows it, but the site itself has no reason to do anything about it. I'm not saying do it, but I'm saying if you do it somewhere it's not going to get taken down. I am a huge proponent of commercial regulations. They make the free market work for society. But this is one of those cases where regulation defeats the purpose. I like Prusa, the company and the person. They're only in this mess because they want to take an active role in their site and because they're so proud to continue being a Czech company. I get the sense that they haven't fully grasped the situation they're in, that the rest of the world can willfully ignore illegal content with zero repercussions and they alone have to follow the rules. And I like the Benchy. I like the guys who designed it. I also like the remixes and the people who designed them. I don't give a shit what Daniel and Paulo think about consistency. Their choice of license might be stupid and misguided, but you know what? I can deal with that myself. This is a direct open letter to the NTI group. I want to buy the Benchy. I want to buy all rights related to the 3D Benchy right now in cash. From your perspective, the 3D Benchy is a valueless, radioactive hot potato, and as long as it's on your books, this exact same public relations meltdown is going to flare up again and again. Hit me up at partnerships@voidstarlab.com. If I gain ownership of the 3D Benchy, I promise to transfer the file to the public domain as expeditiously as possible and provide a blanket license for anyone to use any copyrights, which may or may not exist, on the condition that they thank the original authors, Paulo Keefe and Daniel Norrie.
Speaking of an open license to the Benchy, now I'm going to tell you how to get that now. The copyright owner published the Benchy to My Mini Factory with a license that lacks any restrictions. If MTI Group were to change the license on My Mini Factory, then only those who had downloaded it under the less restrictive license would have it under that license. While it is still published on My Mini Factory under the less restrictive license, people can continue to download it under that license. Additionally, the license is irrevocable. If NTI were to contact you directly and attempt to revoke your unlimited license that you obtained by downloading it from My Mini Factory, they could not, under US law anyway. So download it now before the license on My Mini Factory is updated. This is, of course, my professional legal opinion that is correct under many circumstances, but it may not apply to you and is not legal advice. Also, instead of the Benchy, you can do the 3D Bodhi, which is released by OU Pablo, and it is under a CC by SA license, which requires attribution. Honestly, I think if you're going to do a replacement in this community, you probably want to make it CC0 license. And then one of my subscribers sent me his test, which seems to be getting some traction. Looks like maybe there's been some updates to it as well. There's a lot of comments and feedback. And this one is released under a much more restrictive license, actually. But as Mr. Freedman points out, it might not be copyrightable at all, because it seems to all be functional. Have a good day.